all. Today the session is about workers' rights. Abraham Lincoln, in his first annual message to Congress in the year 1861, December 3rd, talked at length about the correlationship between labor and capital. Labor is prior to and independent of capital. Capital is only the fruit of labor and could never have existed if labor had not first existed. Labor is the superior of capital and deserves much the higher consideration. With this context, I would like to take you all to the scheme of presentation that we would be talking about the workers' rights. First, I would like to look at the rights of the workers in the context of human rights discourse that is happening internationally and nationally. Second, understand the role of International Labour Organization in upholding the workers' rights. Thirdly, the international conventions leading to the acknowledgement of workers' rights. Then we come to the national level, how the Constitution of India reflects the aspiration of workers. Then we move on to the specific legislative framework upholding the rights of workers, specifically in the Indian context. Then we move on to the prominent judgments from the Apex Court upholding the rights of the workers. Then we will look into the challenges that arise from the law in text, the law in context, and the law in action. We then later on move to the proposed labour reforms in view of the labour governance, and we will end up with the concluding observations. Let's see how human rights are interrelated with the workers' rights. Human rights are considered valuable for workers. Why? Because they give workers a voice and offer political and moral space for the most vulnerable of groups such as the unorganized, the underskilled and undocumented workers. They demand that the law protect workers and that no one can easily do away with them. Finally, with human rights to back them, workers are able to refuse exploitation done in the name of efficiency. Connecting workers' rights to human rights shows that workers' rights are vital and must not be traded off casually. Respect for the clearly enshrined international legal rights afforded to all workers is at the foundation of democratic, economic and social development. To look into the international legal developments happening in the rights of the workers scenario, importance of providing economic justice was understood as a crucial part of the international movement to secure peace and stability. Article 23 of the League of Nations, Covenant, included the fair and humane conditions of labour for men, women and children, and envisioned the establishment of international organizations to realize this objective. This goal was the focus of the International Labour Organization, established in 1919 in Paris as an agency of the League of Nations, following the Treaty of Versailles, which ended the World War I. ILO is considered to be the trendsetter for the labour standards and principles universally. ILO's vision emerged from the premise that universal lasting peace can be established only if it is based upon decent treatment of working people. The Declaration of Philadelphia in 1944 proclaimed the ideology that labour is not a commodity to be exploited. The ILO Charter of General Legal Principles included rights like rights of association, collective bargaining, equal rights for women, and abolition of child labour and limits on working hours. In 1946, ILO became the first specialized agency within the United Nations and continued advocating for labour and human rights worldwide. As a tripartite agency, the ILO brings together the collective efforts of representatives of government, the employers and the workers to negotiate, draft and implement labour standards. And India was a founder member in 1919 when ILO was being set up. International Covenant on Economic, Social and Cultural Rights, which was adopted in 1966, in its Article 6 talks about The state's parties to the present covenant recognize the right to work, which includes the right of everyone to the opportunity to gain his living by work which he freely chooses or accepts, and will take appropriate steps to safeguard this right. Article 7 went a step ahead and it proclaimed rights of everyone to the enjoyment of just and favorable conditions of work with regard to fair wages and equal remuneration for work of equal value without distinction of any kind, in particular women being guaranteed conditions of work not inferior to those enjoyed by men with equal pay for equal work. The disproportionate number of children exploited was addressed in Article 10, which said at length, special measures of protection assistance should be taken on behalf of all children and young persons without any discrimination for reasons of parentage or other conditions. Children and young persons should be protected from economic and social exploitation. States should also set age limits below which the paid employment of child labor should be prohibited and made punishable by law. Moving on to the constitutional vision on labor force in India. The history of labor legislation in India is intertwined with the history of colonialism unleashed by the British government. The preamble of the Constitution of India has wedded itself to the philosophy of justice, social, economic and political. Part 3, the Fundamental Rights chapter in the Constitution of India, talks about workers' rights in general. Article 14 reflects the concept of equality before law. Article 16 mandates that there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state, and that no citizen shall, on grounds only of religion, race, caste, sex, descent, place of birth, residence, or any of them, be ineligible for or discriminated against in respect of any employment or office under the state. Article 19(1)(c) of the Constitution of India is an enabling provision to form associations, which includes formation of trade unions for espousing the cause of the workforce. Article 23 prohibits traffic in human beings and forced labor. Child labor is considered gross violation of the spirit and provisions of the Constitution. Article 24 of the Indian Constitution prohibits abolition of employment of children below the age of 14 years in dangerous jobs like factories and mines. Moving on to the Part 4 of the Constitution of India, Directive Principles of State Policy. These mandates are directives to the legislature and executive organs of the state, which are committed to make, interpret and enforce law. They reflect the transition from a police state to the welfare state policy concept. Part 4, Directive Principles of State Policy, discusses at length the rights of the workers, starting with Article 38, which talks about promotion of welfare of all the people. Article 39A, right to an adequate means of livelihood for men and women equally. Article 39D, which talks about equal pay for equal work for both men and women, which later on got reflected into the spirit coming up within the Equal Remuneration Act in 1975. Article 39E, it directs the state to ensure that its policy secures the health and strength of workers, men and women and children are not abused, and that the citizens are not forced by economic necessity to take to vocations unsuited to their age or strength. Article 41 discusses about right to education, public assistance in cases of unemployment, old age, sickness, disablement and other cases of undeserved want. And that's where the legislation within the national context, the National Rural Employment Guarantee Act of 2005 comes into the picture. Article 42 talks about just and humane conditions of work, but also for maternity relief. And that's where the legislations like Maternity Benefit Act of 1961, the Factories Act of 1948, etc. discusses at length the safety, the security and the health and welfare measures that is to be adopted by the employer whenever the interest of the workers are involved. Article 43, it discusses that the state should endeavor to secure by suitable legislation or economic organization or in any other way to all workers, agricultural, industrial or otherwise, work, a living wage, conditions of work ensuring decent standard of life and full enjoyment of leisure and social and cultural opportunities. Here comes in the national legislation called the Contract Labour Regulation and Abolition Act of 1970, the Minimum Wages Act of 1948 and the Employees Provident Fund Act. Article 43A discusses about the ideology, the workers' participation in the management activities. Article 45, free and compulsory education for the promotion of educational and economic interests of weaker sections. Article 47, improvement in the level of the standard of living and of public health. In total, the essence of directive principles of state policy, we can call it as coming up with a socialistic pattern. Whenever we talk about Articles 38, 39, 40 and 41, Article 38.1 discusses about the socio-economic and political justice. Article 38, Clause 2, 44th Amendment talks about the group equality. Article 39, Clauses A, B and C talks about the egalitarian operation of economic and social system. Article 41, 42 and 43 talks about the social security concept envisaged within the national context. Coming to the legislative competence, to see that these constitutional aspirational goals are put into operation, legislature is mandated to make the laws for the working force in India. Labour is a subject in the concurrent list of the Indian Constitution and is therefore in the jurisdiction of both central and state governments. Both central and state governments have enacted laws on labour issues. We have around 45 central labour legislations and more than 200 state legislations coming up in different or specific occupations. To talk about the jurisdiction of the Union list to make laws with regard to the workers' rights in India. Entry number 5 talks about regulation of labour and safety in mines and oil fields. Entry number 61, industrial disputes concerning union employees. Entry number 65, union agencies and institutions for vocational, training, etc. comes within the domain of union list. Then we have the concurrent list, which includes entry number 22, trade unions, industrial and labour disputes. Entry number 23, social security and insurance, employment and unemployment. Entry number 24, welfare of above including conditions of work, provident funds, employers' invalidity and old age pension and maternity benefit. Entry number 36 and 37 specifically talks about laws with regard to factories and boilers. All these issues, subject matters comes within the domain of concurrent list, wherein both central government and the state government can make laws. Now let's look into some of the factors responsible for the shaping of Indian industrial laws. International covenants and recommendations from ILO, the human rights conventions and standards that have emerged from the United Nations scenario, prevailing social and economic conditions then and now, views and philosophies expressed by important nationalist leaders during the days of national freedom struggle, deliberations of the various sessions of the Indian Labour Conference and the International Labour Conference, the Constitution of India comprising of the Trinity, the Preamble, the Fundamental Rights Chapter and Part 4, that is the Directive Principles of State Policy, then recommendations of the various national committees and commissions like First National Commission on Labour, 1969 under the chairmanship of Justice Gajendra Gadkar, National Commission on Rural Labour in 1991, Second National Commission on Labour 2002 under the chairmanship of Ravindra Verma, National Commission for Enterprises in the Unorganized Sector, popularly called as NCEUS report, coming up in 2009 under the chairmanship of Dr. Arjun Sengupta, and not the least, the proactive judicial rulings from the Apex Court on labour-related matters, specifically pertaining to bonded labourers, child labourers, minimum wages, contract labourers, etc. To talk about the rights-based perspective in the context of workers' rights, I would like to bring in Harold Laski in his A Grammar of Politics, published in 1925. The concept of rights that he has envisaged. He says, rights are those conditions of social life without which no man can be his best self. They are the social conditions necessary for the development of one's desires and personality. Thus, rights create an environment in which individual feels empowered, becomes self-confident and develops him or her in all the aspects of life. In the Indian workforce scenario, there has been a transition from the need-based approach to the rights-based approach of the workforce, resulting in legislations protective in nature at the behest of the appropriate government following the lines of welfare state policy. The prominent labor legislations can be categorized as 1. Laws relating to industrial relations in India, consisting of Industrial Disputes Act of 1947, the Trade Unions Act of 1926, Industrial Employment Standing Orders Act 1946, and the Contract Labour Regulation and Abolition Act 1970. We have another set of legislations relating to wages which are protective in nature, comprising of the Payment of Wages Act 1936, the Minimum Wages Act 1948, the Payment of Bonus Act 1965, Equal Remuneration Act 1976. Yet another classification of legislation comes within the domain of social security, addressing the rainy days of life like old age, unemployment, disability, illness, death, maternity, occupational diseases, employment injury, etc. And they are dealt through piecemeal legislations like Employees Compensation Act of 1923, the Employees State Insurance Act of 1948, the Employees Provident Fund and Miscellaneous Provisions Act 1952, the Payment of Gratuity Act 1972 and the Maternity Benefit Act 1961. These legislations specifically addresses the social security and welfare aspects of the workers within the national context. We have another set of classification emanating from the needs that are very much in tune with the workers in specific occupations, processes and activities. They are laws related to specific industries which are protective and welfare oriented in nature, like the Factories Act 1948 applicable to factory workers, Plantation Labour Act 1951 specifically applicable to plantation labourers, Mines Act 1952, the Dock Workers Safety, Health and Welfare Act 1986, Building and Other Construction Workers Regulation of Employment and Conditions of Service Act 1996, etc. The uniqueness of these legislations is that they are occupation and work specific, so as to address specifically the grievances arising out of such occupations, processes or activities. Neither category of laws relates to equality and empowerment of women, keeping in tune with the constitutional philosophy of reducing inequalities and discrimination at workplace, which could be reflected in the form of sexual harassment of women at workplace, Prevention, Prohibition and Redressal Act 2013. Another classification of legislation belongs to the deprived and disadvantaged sections of the society, the so-called vulnerable and the marginalized. And some of the legislations are the Bonded Labour System Abolition Act of 1976, the Child Labour Prohibition and Regulation Act of 1986, including the Amendment Act of 2016, the Interstate Migrant Workman Regulation of Employment and Conditions of Service Act 1979, etc. Another set of legislation deals with miscellaneous processes or situations like laws related to employment and training, employment exchanges, apprentices and other miscellaneous subject matters like war injuries, personal injuries, fatal accidents, etc. Coming to the implementation aspect, the manner in which these legislations are implemented and enforced is through different stakeholders involving certain national level institutions, the Labour Department primarily, and different ministries gets involved depending upon the mandates of the concerned ministries. Let's look into some of the labour laws enacted by the central government, where the central government has a sole responsibility for enforcement. There's a long list of legislation coming under this particular classification, starting with the Employees State Insurance Act 1948, the Employees Provident Fund Act of 1952, the Dock Workers Act of 1986, the Mines Act of 1952, the Beedi Workers Welfare Cess Act of 1976, the Limestone and Dolomite Mines Labour Welfare Fund Act 1972, the Sini Workers Welfare Cess Act 1981, the Beedi Workers Welfare Fund Act 1976, the Sini Workers Welfare Fund Act 1980. Coming to the implementation aspect, the manner in which these legislations are implemented and enforced is through different stakeholders involving certain national level institutions, the Labour Department primarily, and different ministries gets involved depending upon the mandates of the concerned ministries. Let's look into some of the labour laws enacted by the central government, where the central government has a sole responsibility for enforcement. There's a long list of legislation coming under this particular classification, starting with the Employees State Insurance Act 1948, the Employees Provident Fund Act of 1952, the Dock Workers Act of 1986, the Mines Act of 1952, the Beedi Workers Welfare Cess Act of 1976, the Limestone and Dolomite Mines Labour Welfare Fund Act 1972, the Sini Workers Welfare Cess Act 1981, the Beedi Workers Welfare Fund Act 1976, the Sini Workers Welfare Fund Act 1981. Some of the labour laws enacted by the central government and enforced both by central and state governments. To quote a few, the Child Labour Prohibition and Regulation Act 1986, the Building and Other Construction Workers Act 1996, the Contract Labour Act 1970, the Equal Remuneration Act 1976, the Industrial Disputes Act 1947, the Industrial Employment Standing Orders Act 1946, the Interstate Migrant Workman Act of 1979, and the list continues, and it involves many other legislations of this kind. We have another set of labour laws enacted by the central government and enforced by the state governments. To quote a few, the Employers Liability Act 1938, the Factories Act of 1948, the Motor Transport Workers Act 1961, the Personal Injuries Emergency Provisions Act 1962, the Plantation Labour Act 1951, the Employees Compensation Act 1923, the Bonded Labour System Abolition Act 1976, the Beedi and Cigar Workers Conditions of Employment Act 1966, and the list goes on. These were just few examples as to how its enforcement happens. Let's have a bird's eye view of the major labour legislations in India. We will start with the law relating to the industrial relations. The most prominent among them is the Industrial Disputes Act of 1947. The objective of this legislation was to secure industrial peace and harmony by providing machinery and procedure for the investigation and settlement of industrial disputes by negotiations. It is applicable irrespective of the skill level of the worker, but it is not applicable to staff that work in management or administrative positions or as supervisors whose pay exceeds Rs 10,000 per month. This legislation defines industry, and the definition is to be interpreted and understood at the practical level in consonance with the epoch-making judgment of Supreme Court, the BWSSB versus Rajappa, coming up in the year 1978, the judgment delivered by Justice Krishna. We have dispute resolution forums, both non-adjudicatory mechanisms and adjudicatory mechanisms. The non-adjudicatory mechanisms includes conciliation officer appointed by the appropriate government, board of conciliation, court of inquiry, grievance redressal machinery, and industrial arbitration for resolving the industrial disputes. Adjudicatory mechanism comes up with different forums like Labour Court, Industrial Tribunal, and National Tribunal. The Act also makes provision for individual disputes to be deemed as industrial disputes in certain cases and makes access to justice a reality by enabling the workmen to approach the Labour Court directly to resolve the dispute. Provisions regulating strike both in the public utility services and non-public utility services and lockout in the industrial establishments are incorporated with necessary specificities. Penalty regarding illegal strikes and lockout is also stipulated under the Act. The Act envisages situations of economic exigencies leading to involuntary unemployment like layoff, retrenchment, closure of industries, and also situation of transfer of industrial establishment wherein compensation is made available to workmen suffering out of the same. Special provisions regarding protected workmen affiliated to registered trade unions and adjudicatory mechanisms under section 33A relating to adjudication as to whether conditions of service, etc., changed during pendency of proceedings. We do have provisions on unfair labour practices relating to situations under the 5th schedule of the Act, envisaged under the legislation, which makes it very comprehensive in dealing with different kinds of industrial disputes that may come up in the process of employer-employee relationship. The Act in total has 5 schedules attached. Moving on to another prominent legislation, Trade Unions Act of 1926. The presence of trade unions establishes a healthy relationship between the employer and workmen with a sense of responsibility towards each other. The objective of this legislation was to provide for the registration of trade unions in India and for the protection of the same. It defines a law relating to registered trade unions. Registration is not a compulsory process but something voluntary. And it talks about the mode of registration, application for registration, provisions to be contained in the rules of the trade union, minimum requirement for the membership of a trade union, rights and liabilities attached to the registered trade unions, cancellation of registration, appeal provisions, amalgamation and dissolution of trade union. The authority called as Registrar of Trade Unions is appointed by the appropriate government for each state who is vested with the responsibility to register trade unions. The central legislation is silent about recognition of trade unions, and many state legislations like Maharashtra and Madhya Pradesh has got provisions incorporated regarding recognition of trade union. Another prominent legislation is Industrial Employment Standing Orders Act of 1946. Testimony of the protective role by the state is coming up with uniformity and consistency for the service conditions and rules applicable to workmen while in employment, which replaced the system of employment at the whims and fancies of the employer. So this act comes up with the objective to require employers in industrial establishments to define with sufficient precision the conditions of employment under them and to make the said conditions known to the workmen employed by them. The act includes well thought out steps like submission of draft standing orders by the employer, the applicability of model standing rules to the establishment during the period from submission of the draft to certification of standing orders happen. Principles of natural justice being rendered by the authorities who belong to the Labour Department appointed by the appropriate government to the trade unions and workmen concerned of the establishment on whose behalf the draft is submitted. Standing orders to satisfy the rules and legislative intent of the Act. Provision for certification and if necessary for modification. Existence of an appellate authority to hear appeals from either the employer or trade unions aggrieved by the certified standing orders, etc. It shall be the duty of the certifying officer or the appellate authority to adjudicate upon the fairness or reasonableness of the provisions of any standing orders. The schedule to the Act sets out the matters to be provided in standing orders under the Act. There are 11 items included in the schedule. The first 10 items deals with specific matters connected to the employment, and the 11th item is of residuary nature, which authorizes for inclusion of any other matter which may be prescribed. Contract Labour Regulation Abolition Act of 1970 is a piece of legislation which regulates the employment of contract labour and follows a two-pronged approach of abolition of contract if possible by the appropriate government subject to the statutory provisions under section 10 of the legislation, or to regulate the same if contract labour is inevitable to be formed. The Act is applicable to establishments having in which 20 or more workmen are employed or were employed on any day of the preceding 12 months as contract labour, and also to every contractor who employs or who employed any day of the preceding 12 months 20 or more workmen. An establishment which performs an intermittent or casual nature of work is excluded from the applicability of the Act. Mandatory provision for registration of the principal employer and licensing of the contractor is envisaged through this particular legislation. The principal employer is mandated to provide the essential welfare amenities like canteens, restrooms, drinking water facilities and first aid facilities with regard to establishments having more than 100 contractual labourers if in case the contractor has not provided so. If the contractor fails to make payment or makes short payment, then the principal employer shall be liable to make payment of wages in full or the unpaid balance and recover the amount so paid from the contract. Let's move on to the prominent legislations relating to wages. They are popularly called as wages legislations in the Indian context. To start with, we will have a look at the Minimum Wages Act of 1948. While wages in the organized sector are determined through negotiations and settlements between employer and employees, on the other hand, in unorganized sector, where labor is vulnerable to exploitation due to illiteracy and does not have effective bargaining power, the intervention of the government becomes necessary. The object of Minimum Wages Act 1948 is to provide for fixing and revising minimum wages in certain employments in order to stop sweated labor and prevent the exploitation of unorganized labor. In this context, it is interesting to note that the Indian labor force consists of 93% of the unorganized workforce and the rest 7% comes within the organized sector. That's where the importance of this legislation again increases. The norms for fixing minimum wage rate are based on different parameters like 3 consumption units per the earner, minimum food requirement of 2,700 calories per average Indian adult, cloth requirement of 72 yards per annum per family, rent corresponding to the minimum area provided under the government's industrial housing scheme, fuel, lighting and other miscellaneous items of expenditure to constitute 20% of the total minimum wage, children education, medical requirement, minimum recreation including festivals and ceremonies, and provision for old age, marriage, etc. should further constitute 25% of the total minimum wage. The enforcement of the provisions of Minimum Wages Act in the central sphere is secured through the officers of Central Industrial Relations Machinery. Insofar as state sphere is concerned, the enforcement is responsibility of the respective state government or the union territory. Certain prominent judicial decisions emphasize the point that payment of wages at less than a minimum need-based wage would amount to extracting forced labor and hence would be unconstitutional. We have the next law coming up, Payment of Wages Act 1936 and the Amendment Act of 2017. The object of this legislation is to regulate the payment of wages to certain classes of persons employed in industry. The Act applies to the payment of wages to persons employed in any factory, to persons employed upon any railway, by a railway administration, or either directly or through a subcontractor by a person fulfilling a contract with a railway administration, and to persons employed in an industrial or other establishment. The Act guarantees payment of wages on time without any deductions except those authorized under the legislation. The Act categorizes the authorized or legal deductions from the wages at the behest of the employer. The existing wage limit for applicability of the Act has been enhanced from Rs 18,000 per month to Rs 24,000 per month. Equal Remuneration Act 1976 is in consonance with the constitutional policy of Article 39D that mandates equal pay for equal work for both men and women workers. The objective of the Act obviously provides for protection against discrimination of women workers on the ground of sex about the payment of equal remuneration in the matter of employment. It addresses the gender perspective and the gender pay gaps that exist in practice. The Ministry of Labour and the Central Advisory Committee are responsible for enforcing this Act. The Act doesn't make a distinction like employment or the period of employment and applies to all workers even if engaged only for a day or few days. For any recruitment or any condition of service after recruitment like promotions, training or transfer for the same or similar nature of work, the employer will not make any discrimination against women except where the employment of women in such work is prohibited or restricted by or under any law for the time being in force. Payment of Bonus Act 1965 is yet another wages legislation that provides for the payment of bonus to persons employed in certain establishments employing 20 or more persons on the basis of profits or on the basis of production or productivity. There is a minimum bonus and maximum bonus fixed. Minimum bonus is of 8.33% payable by every industry and establishment under the Act. The maximum bonus, including productivity-linked bonus that can be paid in any accounting year, shall not exceed 20% of the salary or wages of an employee. Under the Payment of Bonus Amendment Act, eligibility limit for payment of bonus is enhanced from Rs 10,000 to Rs 21,000 per month, and the calculation ceiling from Rs 3,500 to Rs 7,000 or the minimum wages. According to the 2015 Amendment Act, ceiling amount, the maximum limit of Rs 7,000 is considered as wage or salary for calculation of bonus. Any agreements made between the employee and employee regarding the non-payment of bonus is not valid. If any such agreement is made in between the employer and employee, permission of the government is needed. Let's move on to the social security legislations, the prominent 5 and 1 then. To start with, the Employees Compensation Act of 1923. The objective is to impose an obligation upon the employers to pay compensation to workers in cases of employment injury due to accidents arising out of and in the course of their employment, and also in cases of occupational diseases. The scheme of the Act is not to compensate the worker in lieu of wages. The general principle is that a worker who suffers an injury in the course of his employment which results in a disablement should be entitled to compensation, and in the case of fatal injury, his dependents should be compensated. The Act is applicable to employees working in the employments mentioned under Schedule 2 of this legislation. Calculation of the compensation is made on the monthly wage or salary of the employee. The amount of compensation varies in cases like employee's death, permanent total disablement, permanent partial disablement, temporary disablement, etc. The amount of compensation to be paid depends on the nature of the injury and the average monthly wages and age of employee. The minimum and maximum rates of compensation payable for death, in such cases it is paid to the dependents of the workman, and for disability have been fixed and is subject to revision from time to time. Employees' Compensation Commissioner is the authority envisaged to settle the disputes regarding compensation as between the employer and the employee. Next, Employees State Insurance Act of 1948. The goal of socio-economic justice enshrined in the Directive Principles of State Policy under Part 4 of our Constitution, in particular Articles 41, 42 and 43, gets reflected through this legislation. The ESI Act applies to non-seasonal power-using factories or manufacturing units employing 10 or more persons and non-power using establishments employing 20 or more persons. The wage limit of an employee has been revised from Rs 15,000 per month to Rs 21,000 per month. The administration of this legislation is done by an apex corporate body called the Employee State Insurance Corporation, ESI Corporation. ESI Corporation controls the whole fund of the ESI Corporation directly. It comprises of such members representing vital stakeholders in the field that include employee, employers, the central and state government, representatives of the parliament and medical profession. Let's look to the benefits that have been conferred through this legislation. The benefits are medical benefits, sickness benefits comprising of extended and enhanced sickness benefits, maternity benefits, funeral expenses, disablement benefits, dependence benefits, vocational rehabilitation, free supply of physical aids and appliances such as crutches, wheelchairs, spectacles and other such physical aids, preventive health care services such as immunization, family welfare services, HIV or AIDS detection and treatment, medical bonus paid to an insured woman or in respect of the wife of an insured person in case she does not avail hospital facilities of the scheme for child delivery, etc. Employees Provident Fund and Miscellaneous Provisions Act 1952 was enacted with the main objective of providing insurance to workers and their dependents during the rainy days, called as old age, retirement, discharge, retrenchment or death of the workers. It is applicable to every establishment which is engaged in any one or more of the industries specified in Schedule 1 of the Act, or any activity notified by the central government in the official gazette and employing 20 or more persons. The Act is administered by the Government of India through Employees Provident Fund Organization, popularly called as EPFO. The benefits accruing from this particular legislation are institution of provident funds, family pension funds, and deposit-linked insurance funds for the employees in the factories and other establishments through three schemes: Employees Provident Fund Scheme 1952, Employees Deposit Linked Insurance Scheme 1976, and Employees Pension Scheme 1995, replacing the Employees Family Pension Scheme 1971 to the Employees and Old Age and Survival Benefits. A long-term protection and security to the employee and after his death to his family members, and timely advances including advances during sickness and for the purchase or construction of a dwelling house during the period of membership. Payment of Gratuity Act 1972 provides for a scheme for the payment of gratuity to employees for their unblemished continuous service of 5 years rendered to the employer for workmen engaged in factories, mines, oil fields, plantations, ports, railway companies, shops or other establishments in which 10 or more employees are employed. The present upper ceiling on gratuity amount under the Act is Rs 10 lakh. However, with implementation of 7th Central Pay Commission in case of government servants, the ceiling now is Rs 20 lakhs effective from 1/1/2016. The employer can withhold or forfeit gratuity wholly or partially even if employee has completed 5 years if the employment of the said employee has been terminated for disorderly conduct or any other misdemeanor or an act tantamounting to violence, provided that such offence is committed by him in the course of the employment. If the amount of gratuity is not paid by the employer within the prescribed time to the said person, he or she has the right to file a complaint to the controlling authority under the Payment of Gratuity Act within the area where the employer's establishment is situated or where the employee was working at the time of termination. Maternity Benefit Act 1961 to be read with Amendment Act of 2017. It aims to regulate employment of women employees in certain establishments for certain periods before and after childbirth and provides for maternity and certain other benefits. It is applicable to all establishments which are factories, mines, plantations, government establishments, shops and establishments under the relevant applicable legislations or any other establishments as may be notified by the central government. The eligibility condition to avail benefits under this particular act is the parameter of 80 days continuous service. The Maternity Benefit Amendment Act has increased the duration of paid maternity leave available for women employees from 12 weeks under the 1961 Act to 26 weeks. Maternity leave for adoptive and commissioning mothers is also envisaged under the Amendment Act, which is an improvement from the earlier legislation. The new Amendment Act makes creche facility mandatory for every establishment employing 50 or more employees. Women employees would be permitted to visit the creche 4 times during a day. 2 nursing breaks for the mother a day until the child attains the 15 months is also envisaged under the Act. When a pregnant woman absents herself from the work, in accordance with the provisions of this Act, it shall be unlawful for her employer to discharge or dismiss her during or on account of such absence or give notice of discharge or dismissal in such a day that the notice will expire during such absence or to vary to her disadvantage any of the conditions of services. The Maternity Benefit Amendment Act makes it mandatory for employers to educate women about the maternity benefits available to them at the time of their employment. Unauthorized Workers Social Security Act 2008 highlights the major unauthorized worker categories and includes migrant workers under the ambit of wage workers. The Act provides for formulation of schemes by the central government for different sections of unorganized workmen on matters relating to life and disability cover, health and maternity benefits, old age protection, and any other benefit as may be determined by the central government. It provides for formulation of schemes relating to Provident Fund, employment injury benefits, housing, educational schemes for children, skill upgradation, funeral assistance and old age homes by the state government. The legislation envisages a National Social Security Board at the central level under the chairmanship of the Union Minister for Labour and Employment, which also gets replicated at the state level, comprising of representatives of unorganized workers, employers of unorganized workers, as well as persons belonging to the scheduled castes, scheduled tribes and other minorities and women. The 10 schemes enlisted, which were already made available to the BPL card holders, gets extended to the unorganized workers registered under the Act. Depending upon the eligibility criteria envisaged as per the schemes, the social security benefits are made available to the unorganized workers. Let's move on to another specific legislation relating to child labour. Child Labour Prohibition and Regulation Amendment Act 2016. The Act has completely banned employment of children below 14 in all occupations and enterprises except those run by his or her own family, provided that education does not get handled. Addition of a new category of persons called adolescent is envisaged that defines children between 14 to 18 years as adolescents and bars their employment in any hazardous occupations. The Act has a provision of creating a rehabilitation fund for the rehabilitation of children. The number of hazardous occupations has been brought down from 83 to 3. The 3 occupations envisaged under this particular legislation are mining, inflammable substances and hazardous processes under the Factories Act. The Act empowers Union Government to add or omit any hazardous occupation from the list included in the Act. The Act empowers the government to make periodic inspection of places at which employment of children and adolescents are prohibited. Government may confer powers on a district magistrate to ensure that the provisions of the law are properly carried out and implemented. With passing of this new legislation, Indian law is now aligned with the International Labour Organization Convention. With passing of this new legislation, Indian law is now aligned with the ILO Convention, Abolition of Worst Forms of Child Labour Convention. Let's look into some of the laws related to deprived and the disadvantaged sections. They are Bonded Labour System, Abolition Act of 1976, the Interstate Migrant Workman, Regulation of Employment and Conditions of Service Act 1979. To have much more clarity with regard to how the judiciary has come up or the judicial activism has happened in upholding the rights of the workers in the national context, let's look to some of the prominent cases coming up from different legislations. The understandings of human dignity and right to life and thereby extending the arms of judiciary to interpret the cause of the entrenched class are reflected through monumental cases in the Indian context. To cite a few of them, some of the prominent cases related to bonded labourers, like Bandhu Mukti Morcha versus Union of India, a petition that came up in the year 1982. People's Union for Democratic Rights versus Union of India, again in the year 1982. This was a prominent case wherein the apex court proclaimed, when a person provides labour of service to another for remuneration, which is less than the minimum wage, the labour or service provided by him clearly falls within the scope and ambit of the words forced labour under Article 23 of the Constitution of India. Another prominent case in the context of bonded labourers upholding the rights of the workers involved was PUCL versus State of Tamil Nadu and others in the year 1985. Balram and others versus State of Madhya Pradesh and others, wherein the apex court played a vibrant role in directing rehabilitation of freed bonded labourers. Neercha Chowdhury versus State of Madhya Pradesh in the year 1984 was very prominent in the context of a presumption that was upheld by the Supreme Court in favour of bonded labourers when Justice Bhagwati observed that whenever it is shown that a labourer is made to provide forced labour, the court would raise a presumption that he is required to do so in consideration of an advance received by him and is therefore a bonded labourer. The onus of proof for rebutting the presumption rests with employer or the government. This presumption had gone a step ahead in addressing the plight of bonded labourers who are the so-called silenced victims. Santal Pargana Antyodaya Ashram versus State of Bihar and others in the year 1987 was yet another prominent case coming up in this context wherein the apex court upheld the rights of bonded labourers. One of the prominent cases on child labour was the labourers working on Salal Hydro Project versus State of Jammu and Kashmir in the year 1984. Another case in MC Mehta was the state of Tamil Nadu in the year 1991. The Supreme Court has held that children below the age of 14 years cannot be employed in any hazardous industry. Exhaustive guidelines was laid down as to how state authorities should protect economic, social and humanitarian rights of millions of children working illegally in public and private sectors. Equal pay for equal work was yet another context in which Supreme Court came up with the situation of upholding the rights of Randhir Singh versus Union of India in the year 1997. Supreme Court held that although the principle of equal pay for equal work is not expressly declared by our constitution to be a fundamental right, but it is certainly a constitutional goal under Articles 14, 16 and 39C of the Constitution of India. U. Unichoy and others versus the state of Kerala coming up in the year 1962 was a prominent case in the context of Minimum Wages Act of 1948, wherein the Supreme Court upheld the constitutional validity of this legislation and declared that incapacity to pay minimum wages is an irrelevant consideration in fixing minimum wages. Sanjay Roy versus state of Rajasthan in the year 1983, the Supreme Court went a step ahead again in proclaiming the rights of the workers. Where a person provides labour or service to another for remuneration which is less than the minimum wage, the labour or service provided by him clearly falls within the meaning of words, the forced labour, and attracts the condemnation of Article 23. Contract Labour Regulation and Abolition Act of 1970 was brought in under question in one of the famous cases, Gammon India Limited, etc. versus Union of India and others in the year 1974, wherein Supreme Court upheld many of the provisions of this particular legislation in favour of the contractual workers. Let's look to some of the criticisms. After having looked into many piecemeal legislations on different contexts in which the rights of the workers are enumerated and situations wherein judiciary has upheld the workers' rights, we do face many criticisms from different pockets regarding the legislations, the structure of the legislations, the way it is implemented. The labour literature talks at length many criticism that comes from different pockets regarding the legislation and its implementation. And that's where the challenge starts. There are too many labour laws in India, and they are too old and archaic. They are so rigid and there is no embedded flexibility. Confusing terminologies and definitions are used in many of the legislations. For example, we do find different definitions for workmen in different legislations. Too much of procedural elements are brought in, and punishment provided is very meager, which doesn't have any deterrent effect. The legislations are not effective in achieving the objects. The coverage of law is limited. Lack of implementing staff is yet another problem that persists within the Labour Department. Difficulties in compliances again adds on to that plight. Too many records, registers, notices, returns, etc. adds on to the existing plight of the implementation hurdles. The lack of central legislation on recognition of trade unions, the lack of consensus on national floor level minimum wages, the social security issues of unorganized sector workforce, etc. comes in at length or are being discussed at length as and whenever we talk about the efficiency or the efficacy levels of these legislations that we're talking about. Let's see some of the challenges before the employer. The need for getting permission from appropriate government in the instances of retrenchment, layoff and the closure of enterprises, as reflected through Chapter 5B consisting of bigger establishments of the Industrial Disputes Act 1947 is always contested by the employer. Section 9A of the Industrial Disputes Act 1947, which mandates 21 days notice before affecting any change in the established conditions of service of any employee, which is considered by the employer as an impediment to their growth. The Contract Labour Regulation and Abolition Act of 1970, which provides for engaging contract workers for temporary, seasonal work, but not for the work of a perennial nature. In this context, let's look at the changing labour scenario. The major challenge felt in the Indian scenario is the mounting influx to the unorganized informal economy, which constitutes to about 93% of the unorganized workforce in India and the remaining minuscule 7% of the organized formal sector. Due to employment trend fluctuations, rigidity and non-flexibility of the labor legislations, and poor enforcement rates of the laws, the potential of more chunks of population from the formal economy gets added on to the 93% of the informal economy, as reflected through the Arjun Sengupta's NCEUS report, which testifies to this particular fact. Yet another problem with the changing labor scenario is feminization of labor, leading to gender disparities with regard to wages and also the sufferings and the exploitation that continues as a part of migration. The stark and the contrasting effects like unemployment, underemployment of youth, lack of skilled workmen, large-scale migration in need of sustenance and subsistence, etc. adds on or contradicts the aspirational goals of the 12th five-year plan at the national level and the decent work agenda at the international level flagged off by the International Labour Organization. Let's have a look of what is development as understood by an employer and also the decent work agenda, the transition that has happened in the ideology. At one point of time, ILO was proclaiming about labor is not a commodity to be exploited. By 1998, it has come up to an ideology which says that there should be decent working conditions for the workers. So let's compare and contrast as to what is exactly the problem. From an employer's perspective, what is development? It means more accessibility to multinational corporations, splitting of production units to areas in search of cheap labor, deregulation of labor markets, scrapping of protectionist measures like more lenient health, environment and safety regulations, less rigid labor procedural compliances, lower environmental protection standards, more favorable tax laws that leads to maximization of profits. Now turn the coin to the decent work agenda as envisioned by International Labour Organization. How the decent work should get reflected. That is the perspective of the workers. Access to employment, access to social protection, access to social dialogue, and access to principles and rights. This is where the contradiction begins and ends. Ratification of core conventions is the need of the hour. According to 1998 ILO Declaration on Fundamental Principles and Rights at Work and its follow-up, all ILO member states have an obligation to respect, to promote and to realize in good faith and in accordance with the Constitution 4 categories of principles and rights at work, even if they have not ratified the ILO conventions. So let's see what all are the fundamental principles and rights at work which ought to be ensured. To start with, freedom of association and the effective recognition of the right to collective bargaining. Second, the elimination of all forms of forced or compulsory labor. Third, the effective abolition of child labor. And fourth, the elimination of discrimination in respect of employment and occupation. Let's see to what extent India has ratified these ILO conventions. To attain decent work, respect for core labor standards as enshrined under the 8 core fundamental human rights conventions becomes essential. The 8 fundamental conventions are Freedom of Association and Protection of the Right to Organize Convention 1948, Convention number 87, which is not ratified by India. Second, Right to Organize and Collective Bargaining Convention 1949, Convention number 98, again not ratified by India. Third, Forced Labor Convention 1930, Convention number 29, which is ratified by India in the year 1954. Fourth, Abolition of Forced Labor Convention 1957, Convention number 105, ratified by India in the year 2000. Minimum Age Convention 1973, Convention number 138, again ratified by India in the year 2017. 6. Worst Forms of Child Labour Convention 1999, Convention number 182, ratified by India in the year 2017. 7th Convention, Equal Remuneration Convention 1951, Convention number 100, ratified by India in the year 1958, and the last and the 8th Convention, Discrimination, Employment and Occupation Convention 1958, Convention number 111, again ratified by India in the year 1960. To sum up, two important conventions coming up under the core labor standards, core labor conventions, has not been ratified by India. Out of the 8 conventions, 6 of them has been ratified. Let's have a look at the proposed labor reforms and governance initiatives. Government does follow the new policy of doing of ease with business in India. In line with the recommendations of Second National Commission on Labour, Ministry of Labour and Employment has taken steps for simplification, amalgamation and rationalization of central labour laws and replacing them with 4 labour codes, namely Code on Wages, Code on Industrial Relations, Code on Social Security and Welfare, and Code on Occupational Safety, Health and Working Conditions. The intention behind amalgamation of the labour legislations is that codification of the labour laws will remove the multiplicity of definitions and authorities, leading to ease of compliance without compromising wage security and social security to the workers. A new governance initiative called as Shram Suvidha portal is put into practice in the year 2014 to bring transparency and accountability in enforcement of labour laws and ease the complexity of compliance, catering to 4 major organizations under the Ministry of Labour, namely Office of Chief Labour Commissioner Central, Directorate General of Mines Safety, Employees Provident Fund Organization and Employees State Insurance Corporation. Yet another salient feature of this Shram Suvidha portal is creation of a unique number known as Labour Identification Number or LIN to supplement all other registration numbers such as PF Establishment Code, Employee State Insurance Corporation Registration Number, Contract Labour Registration Number, etc. Online servicing of notices from the Labour Department and online submission of answers with document. Yet another salient feature is employee grievances can now be received online and employer has to clear them and submit proof of clearance. National Policy on Safety, Health and Environmental Workplace is yet another initiative in tandem with the directive principles of state policy. Ratification by India of all the core labour treaties has been taken up as a high priority concern in the Decent Work Country program evolved in India during 2013 to 2017. The overarching theme of Sustainable Development Goals of 2030 talks about no one shall be left behind. The key role of decent work for all in achieving sustainable development is highlighted by the Sustainable Development Goal Target 8, which aims to promote sustained, inclusive and sustainable economic growth, full and productive employment and decent work for all. In this context, let me sum up with a quote by Nelson Mandela, which brings in a proper correlationship between the globalization and its effects going on one side and the need of the hour that ought to happen. Nelson Mandela says, where globalization means, as it so often does, that the rich and powerful now have new means to further enrich and empower themselves at the cost of poorer and weaker. We have a responsibility to protest in the name of universal freedom. Thank you.